The Mexican and American political, social, and economic institutions are starkly different, although some aspects seem similar. The histories of both countries have undoubtedly contributed to these distinctions and parallels. Through analytical comparison between these histories, we are able to understand the contrasting themes that make up the labor unions and trade agreements between and within these two nations. Although Mexico and the United States possess certain similarities, the differences between the U.S. and Mexican labor unions and trade agreements stem from the relationships of the organizations to the states themselves. Mexican labor unions are representatives of workers in urban areas. They are state-controlled, with a membership comprised of approximately 70% of the working population. The federal labor law, enacted in 1931, is the keystone of Mexico's labor legislation. It regulates minimum wages, job security and severance compensation, employee benefits, hiring, seniority, and promotion. The Mexican legislation guarantees job security as long as a job for which the worker was hired exists within the firm. However, the Mexican law provides 14 reasons to vindicate a firm for legal dismissal of a worker. Some of the reasons are disruptive or immoral behaviors, lack of honesty, deliberate damage to tools, equipment or machinery, and endangerment to the security of the workplace. In 1943, the IMSS, or Mexican Social Security Institute, was founded, consolidating and institutionalizing Social Security law. The IMSS provides 6 types of insurance benefits to employers and their relatives, which include health insurance, daycare service for children, life insurance, disability pension, work risk pension, sports and cultural facilities, retirement pensions, and housing loans. Mexico's Institutional Revolutionary Party, or PRI, was established in 1929 to bring the Mexican people together in discovering their own path to self-rule, cutting the cord of dependency on the United States. The PRI has benefited Mexican workers in the following ways. It convinced the government to revise labor laws and regulations. It supported workers' benefits by assisting with negotiations between employers and laborers, and many social welfare services were established, such as medical care, education, and allowances for the home. The first national labor federation in the United States was the National Labor Union, or NLU. It was more of a political organization, functioning at first with some success lobbying for 8-hour workday legislation, and later as a political party campaigning for a program of total reform. The NLU ultimately failed due to its preoccupation with politics and its inadequate perception of the goals of the labor union movement. The American Federation of Labor, AFL, was founded by Samuel Gompers and formed in Columbus, Ohio in 1886. One of the primary goals of the AFL was lobbying for and creating legislation such as prohibition of child labor and a national 8-hour workday. However, like the NLU, the AFL also failed, but the reason is different. The AFL was wedded to a policy of selective recruitment of workers and favored policing industries rather than organizing industries. John L. Lewis founded the Congress of Industrial Organizations, the CIO, in 1935 when troubles with the AFL persisted. The CIO was born out of a fundamental dispute within the U.S. labor movement over how to organize industrial workers. The CIO developed the sit-down strike, which meant workers stayed on their seats doing nothing rather than leave the job site. The AFL and CIO merged in 1955 after a long estrangement. As of today, it is made up of 56 national and international unions, together representing more than 11 million workers. Currently, it is the largest federation of unions in the United States. In April 2008, the AFL-CIO formed a partnership with Enlace, a network of workers' rights groups in Mexico and the United States. The goal of the new partnership is to strengthen both organizations' ability to promote and enforce workplace rights, especially those of low-wage workers. The working worlds of the United States and Mexico began to intersect at the beginning of World War I. Most American workers were siphoned off overseas, and the extreme labor shortage prompted Congress to create a program that allowed approximately 77,000 Mexican workers to enter the country as guests in order to fill the void. The initiative became the first de facto bracero program. With the onset of the Great Depression in the late 1920s, most of the guest workers from Mexico were deported, but the arrival of World War II brought about the need for labor yet again when American workers were sent abroad as part of the war effort. This time, the United States created the real bracero program, signed in 1942. It brought in over 400,000 workers per year during its 22-year span. The braceros, or laborers, worked for railroad companies, growers, and ranchers under independently controlled contracts in the United States by farming associations. When World War II ended, returning servicemen and other American workers wanted their jobs back, forcing out the Mexican laborers from their positions. And in 1954, a massive deportation of illegal immigrants occurred under Operation Wetback, a program devised by the Commissioner of Immigration and Naturalization that led to the bracero program ending in 1964. In conclusion, the distinction between the unions of Mexico and the United States is most evident when analyzed from the point of who controls them ultimately. In the United States, unions are groups of workers with no political affiliation, whereas in Mexico, they are strongly tied to political parties and the government. The trade agreements are also the same in the sense they were designed to benefit both countries, but their inherent differences in structure and ability have created many problems that must be resolved.